Professor Moreland, Melanie Dudley, and all of the people who helped organize this event and who are attending this event. I extend my thanks to you. The title of my talk is Interpreting Islamic Law, and that seems rather broad. So I hope you'll bear with me as I try to walk through what that means and why it is important. So we've heard a lot about originalism last week with the confirmation hearings of Judge Amy Coney Barrett, perhaps future Justice Amy Coney Barrett. And just today, the Senate Judiciary Committee voted to approve her nomination and move to the Senate floor for a confirmation vote on Monday. I timed those events to coincide with my talk on the judiciary and interpretation of Islamic law. Two opposing approaches to law in general. So before we get to Islamic law, two opposing approaches to law in the United States appear prominently in the form of two books and hundreds, perhaps thousands of principles and precedents produced by the methods at play in each book. One of them is by the late Justice Antonin Scalia and the law dictionary magnate, Professor Brian Garner, who published a work called Reading Law in 2012. And their book presents a vision of textualism and originalism that centers on some 57 legal canons, principles of law, and the cases or the precedents that accompany them. They suggest that judges should read only the text according to the way that the framers or authorizing legislators wrote them, and that legal canons, rather than pragmatics or purpose, should guide that task. The dynamic or pragmatic interpretation guru, Professor William Eskridge of the Yale Law School, published his own volume a few years later in 2016, and he called his book Interpreting Law. His book aims to present a vision of pragmatic or dynamic statutory interpretation. And it shows where all those legal canons came from, and it details how most judges actually deploy them. They use them pragmatically as interpretive tools to fill gaps, in some ways to allocate power, and in other ways to say what the law is with respect to purpose or policy-driven factors like the mischief rule. What mischief was the statute trying to address? And the equities of the statute. So the basic disagreement on interpretation is put nicely right in the titles of these two battling books: Reading Law versus Interpreting Law. Reading law presumes a static and original meaning contained in the words of a text and select legal canons, and it preserves the status quo unless a legislature decides otherwise. Interpreting law points to dynamic and evolving meanings of the words of a text alongside a wider set of legal canons as supporting tools for interpreting texts in ways that seek to meet the purpose or the change for which legislation, almost by definition, legislation is legislated in order to change the status quo. So the purpose or change for which the legislation was enacted. So remarkably for me, and frankly, this is what got me into the field of interpretation generally, and interpretation in Islamic law specifically long ago. This basic disagreement in American legal interpretation or American law's approaches to statutory and constitutional interpretation have a precursor and a comparator in Islamic law. So that system lacked a legislator or you might say that it had one legislator, big L, but it lacked a dynamic legislature. So it had an even larger role for text and therefore for legal canons. And so then that begs the question, is Islamic law, as text heavy as it is and as originalist as its followers announce that it is it supposed to be about reading law according to text and originalism in ways that preserve the status quo? And for that matter, empower judges claiming to rely on text when they may in fact be interpreting like any other judge? Or is Islamic law supposed to be about interpreting law according still to text? So like the famous quip, "We're all textualists now." Is it supposed to be about interpreting law according to texts that are supported by some contextual or even extra textual clues that speak to dynamic and evolving meanings of the words of the text? Is it supposed to be about the principle or the mischief for which the divine legislation came down once in full view of the realities of society and societal changes over time and space? And is it about the broad set of legal canons that provide guides or interpretive tools toward those ends? So this talk seeks to answer some of these pressing questions about Islamic law. And I seek to do so not in terms of content necessarily, but approach. And I seek to do so at a time when in the legal and popular conversation, Scalia-esque type originalism and textualism are pitted against newer theories of super-precedent and dynamic statutory interpretation of the type I mentioned earlier. So with similar controversies in mind in the Islamic law context, how are we to make sense of Islam's religious textual origins, myriad manifestations, and sometimes mystifying mullahs who sometimes represent it? How do we, in other words, go about interpreting Islamic law? The answer to that question is lodged in history that I argue can come to light best under the lens of some of these legal theories that we've long used to explain or frankly to do interpretation. And my attempt to show how will start with that history long ago at a moment when the principles and precedents that guide interpretation in Islamic law were first codified in the form of collections of legal canons. That codification really emerged from the ashes of Islam's fallen caliphate in 1258. It followed the invasion of Genghis Khan's Mongols, and it came at a time when the sultan in Cairo had initiated a widespread judicial reform. That much is fairly well known in the history of Islamic law, although I'll take time to unpack how that occurred. But I'll point out now that much less well known is that the jurists of that time instituted their own widespread reform alongside the structural reforms that the sultan imposed. And the juristic and judicial reform came in the form of changes to approaches in interpretation. One principle for every major area of law, drawn from something akin to an interpretive common law, each principle used to help draw on the past in order to resolve questions, open questions in the present. The jurists called these principles legal canons. That's the closest translation of the term qawaid, and there are actually many terms, ashbah, furu' or furuq, and the like. So they call these principles what are the equivalent of our legal canons, and they use them as interpretive tools to adjudicate cases, to pen scholarship, and to teach law. So very similar, again, to legal canons as we know them. The result was a system of interpretive precedent in Islamic law that most onlookers casually, and frankly, most scholars of the field don't realize exist. They also don't realize that this sort of precedent coincides with our use today of legal canons in American theories of interpretation. So between reading law and interpreting law, as you may guess from the title of my talk, Interpreting Islamic Law, my study of the field tells me that Islamic law, read in the light of its own legal canons, is really about interpreting law dynamically with changes with respect to values over time. That basic insight has enormous implications for this moment. And I think how we think of questions of originalism, the structure of the judiciary, and comparability of Islamic law to US law. And all of these are sort of modern or presentist questions that I'm happy to explore in the discussion after the talk. I'm also happy to explore questions about methods of how do we even identify all of these legal canons and make sense of them. There are hundreds or perhaps thousands of them. And I think there are some computational big data ways to approach the question. But what I want to do here, what I want to focus on here, is something that I think is really essential to understanding the landscape of legal canons in Islamic law in ways that are comparable to and different from the ways that we think of them in American law. And I think that what's really essential to understanding them is the centuries-long history that inform the debates in Islamic law. And that history is useful for a couple of reasons. First, it tells us more about Islamic law than seeing Islamic law as a static religion, or whether to see religion and law as static or dynamic. It tells us how to actually make sense of old originalist traditions in modern contexts, once examined through the sheer antiquity, to use one of the late Justice Scalia's terms, of legal canons. Second, I think that history can give us a new lens by which to evaluate some of the very thorny questions of the present that we've seen unfold. And so what I'd like to do in the talk today is to spend the bulk of the remaining time unpacking the history and significance of legal canons in interpreting Islamic law at the moment when they first emerged. So going back to that moment, we begin in the middle of the 13th century. Not long after he took power, a one-time slave soldier, the term for slave soldier is mamluk, and that also ends up being the name of the empire that he would found. This one-time slave soldier by the name of Al-Zahir Baybars radically reformed the judiciary of the reconstituted Eastern Muslim Empire as the first Mamluk Sultan, or the first real Mamluk Sultan. There was a weaker leader before him. The Mongols had really decimated the old seat of the Muslim Empire in Baghdad in the winter of 1258. And they had dismantled the entire Muslim caliphate, and with it, the foundations of the very systems of law and order. Baybars, this new sultan, had in turn helped defeat the Mongols in 1260 and immediately seized the throne. To solidify his hold on his power and territory, he reinstalled a titular caliph whom he purported to represent. He fought the Crusaders. He imposed various economic measures to secure his army and revenue. His focus was on power and political legitimacy through the symbolic use of the caliph and the real use of force. So having established both over the first 5 years of his reign, he then turned to domestic affairs and questions of religious legitimacy and law later on. He began with some tentative reforms in 1262, but it wasn't until 1265, 5 years in, that he ordered a major judicial overhaul. The common view among historians is that the sultan's structural reforms altered a long-standing institutional symbiosis that these same historians credit with guaranteeing a functioning system of Islamic law and governance. So what's the symbiosis? Scholars of Islamic law typically use this term to refer to the idea of legitimacy in early Islamic societies, beginning as early as the 7th century after the death of Muhammad the Prophet in 632. So they relied, the symbiosis meant that there was some reliance after that period on a balance between government leaders and scholars of Islamic law. So in that old system, the going view is that jurists had the religious or the epistemic authority to say what the law is, to borrow a term from Marbury versus Madison. They were the ones who had studied the law, studied interpretive mechanisms, had a pietistic moral outlook, and the best qualified epistemically or religiously to say what the law is. On the other hand, the sultan had, or the caliph, had the power to appoint judges and perform executive duties, including enforcement of court decisions. So judges at this time would then be appointed by the political authority, the caliph or sultan or local governor, but they would have to look to the jurists, these scholars who were sometimes appointed as judges themselves, for the authoritative interpretations of Islamic law, backed by this sort of loose sense of epistemic or religious authority. So in that scheme, we understand the juristic opinions to make up the stuff of Islamic law broadly, Sharia. It's seen as an enduring and authoritative expression of divine will. And the royal decrees form executive policies, siyasa, that could sometimes dictate institutional structures in which the jurists operated, and that oftentimes, as we'll talk about more today, ended up having major effects and getting folded into Sharia itself. The only caveat is that the executive policies were authorized so long as they ensured order and otherwise were perceived thereby as serving the public interest. So in this conventional scholarly account, any executive-led structural changes affected the form of this old symbiosis between the scholar jurists and the leader caliphs, political leader caliphs. But they didn't really alter the form or functions of Islamic law itself, that is, of interpreting Islamic law. I beg to differ. Not many have deeply interrogated whether and how structural changes affect interpretive moves in Islamic law, and therefore help define values or allocate power through interpretation in Islamic law. And it turns out, I argue, that the interpretive developments in Islamic law were just as conspicuous and significant as the structural ones for informing definitions of law and governance. And they were no less affected by the Sultan's structural reforms. So I'd like to explain how, through exploring the initial case and that ostensibly sparked the judicial reforms. And then talking about the legal canons that emerged in the wake of those reforms. What are they? And then finally examining the ways in which those legal canons operated. How did they form the sort of interpretive precedents that I'm arguing are key in familiar ways to American lawyers to interpreting Islamic law? So the case, a little bit of background is that there were two courts in operation simultaneously. There were the sultan's courts, which were extraordinary courts or royal courts of justice, and they operated alongside ordinary courts, courts that were governed by Islamic law and staffed by or overseen by the scholar, jurists, and judges that sat in them. So each week, the Sultan Baybars, held court at the Dar al-Adl, the Palace of Justice, that he had constructed just outside the citadel where he lived in the capital city of Cairo. He used to sit with his top military officials and the single chief judge of the realm, a Shafi'i judge by the name of Ibn Bint al-Az. Shafi'i is one of the many legal schools that exist in Islamic law that are seen as equally authoritative to one another. And I'll tell you a little bit more about them as we go. This was the royal court, which handled extraordinary cases involving government officials, public law matters of crime or taxation, special dispensations or pardons, things that went beyond the ordinary questions of law that would be handled in the courts of the chief judge and his deputies. But nevertheless, the chief judge sat beside the sultan at this special royal court to give input on the Islamic law interpretations of each case, even though the sultan was ultimately the decision maker. On one occasion, in the year 1265, and this gets us to our case, two litigants sought resolution of a matter that was ostensibly a private dispute about trusts and estates, but it turns out to have been much more to it and to implicate the very status of the institutional elite classes under the Mamluks, as well as the proper scope of interpretation for Islamic law. It was the high status of the litigants. They were representatives of a deceased judge and representatives of a high-ranking military official that landed this case in the Sultan's court. So the facts of the case and the direct legal issue at hand were fairly straightforward. The daughters of the military leader were heirs to his estate. They claimed to have bought a house, a large house, from a judge who had passed away while that judge was still alive. But when the judge died, his heirs claimed that when he was alive, the judge had instead converted the property in question into a charitable trust, a waqf, and bequeathed it or its proceeds to them. So the basic question was, who was entitled to the property or its proceeds, the heirs of the judge or the heirs of the military officer? So problems of potential judicial bias rather than the legal issue itself soon revealed themselves. The senior military official who was present at the royal court, he raised objections. It's not entirely clear from the sources what his precise objections were, but they suggest that the problem was twofold. First, a decision for the heirs of the judge would privilege members of the judiciary above members of the military. And as a representative of the military elite, he was there to ensure that their material needs and interests were met. And this, of course, pragmatically made good sense as he and the Sultan, by extension, would have to ensure that the material needs of the military officers on which the Mamluk empire was built were met. So second, a decision for the heirs of the judge was likely only plausible because of some interpretive maneuvering or loopholes that the judge sitting there had gone through. So the military officer surmised that the chief judge had likely interpreted Islamic law or the classical Islamic law of waqfs in a way that exploited some loophole and helped enable the heirs of the judge to even make their claim in the first place. The Sultan turned to the chief judge, not really so much for his detailed legal opinion about the case, but for his response to the senior military officer's criticism. The Sultan asked the chief judge, "Is this how judges are?" The chief judge responded with a vague platitude and said something to the effect of, "Well, there are complications in every case." That said, the chief judge advised that the proper way to proceed would be for the heirs of the judge, presumably to keep possession of the property. If it was with their father until he died, they ostensibly had possession, to reimburse the heirs of the military official for any monies that they might have received, and that they should give the property to the military leader's heirs only if those heirs could confirm sale and could confirm that there was no establishment of a charitable trust during the decedent's lifetime. So essentially, his solution was to make a presumption in favor of conferring the property on the judge's heirs, whether as waqf or property that could be bought and sold, and not to the heirs of the military officer. So this was a fine point of interpretation that involved, or perhaps proposed, two legal canons: waqf over sale and possession over claims of ownership. These presumptions did favor the heirs of the judge, and they could only be overcome by clear evidence, typically two witnesses or firm documentation regarding both the sale and the absence of documentation regarding the waqf that would have been difficult to procure on the side of the military leader's heirs. So the Sultan pressed the chief judge, well, what would happen if the judge's heirs could not locate evidence of a waqf? So would that doom their case? The thought was that the property would likely go to the military officer's heirs. But the same Sultan had early on instituted a policy requiring that the heirs of Mamluk soldiers, even if not military men themselves, were to inherit their decedent family members' estates. So essentially, he had shifted the presumption the other way. And of course, remember, he had an army to feed, literally. But the chief judge replied that, well, if there was no evidence of a waqf, of a charitable trust, then the rule would become, again, according to a presumption or legal canon, that the charitable trust would revert to its original state as private property or usufruct, still for the judge's heirs to keep outright. And moreover, the judge's heirs in that case would not need to return any proceeds from any alleged sale. The sources, again, are somewhat elliptical here, but the implications are that the outcome all depended on the status of the trust. The judge's heirs were to reimburse the military officer's heirs if the sale was improper and still would receive proceeds from the trust, or else they were to keep the proceeds from the property sale, even if it was not specifically bequeathed to them. The point is that either way, the judge's heirs would be the ones to take home something. So who got to keep the property in the end? The judge's heirs or the military officer's heirs? Here, the sources aren't entirely clear on that point, but it seems reasonable to presume that the judge's heirs won, and that they got to keep the property for what came next. Moreover, the chief judge had suggested as much, and he noted that his interpretation of the Islamic law of charitable trusts and estates would render the property of a deceased person ineligible for transfer or sale. But the point of this story is not what actually happened. Instead, the narrators who authored the chronicles in which this case appears focus more on questions of the scope of judicial power that the single chief judge seemed to exert. And Mamluk chroniclers contemporaneously point to this case as the acute incident that sparked the major judicial reform that Sultan Baybars initiated soon after this case. So this major reform that comes in the wake of the case is maybe the first caliphal override of structure arising from a case. He reformed the judiciary in several ways, but the main one was meant to weaken the power of the single chief judge, who again belonged to the single legal school of many, the Shafi'i school. And he distributed judicial responsibilities to the other three mainstream legal schools. He appointed one chief judge for every major approach to Islamic law of his time. That is, for every major school of law or madhab, and he made the Shafi'i judge the first amongst equals in coordinating between them. So to put that in modern terms, that's something like the chief judge had become the Chief Justice John Roberts of his day. That is, if we too had a system of appointing one originalist judge, one pragmatist judge, one textualist judge, sort of a judge for every school of interpretation that we could imagine. So to be sure, the case may have been a contributing cause, but it seems clear it wasn't the only thing prompting the reform. In fact, the sources show that the Sultan had initiated changes to the judiciary even before this case. 3 years prior to the case, in 1262, the Sultan had directed the chief judge then to appoint 3 scholar jurists from the other 3 mainstream approaches to law or legal schools as his deputy judges. But that seems not to have been enough, and it didn't curtail the chief judge's power enough. After the case, perhaps, the Sultan realized that merely deputizing judges was insufficient to curb the outsized power of the chief judge in all manner of cases. And so he recognized that the chief judge had enormous power. Looking backward, it was the famed Abbasid caliph Harun al-Rashid in the 9th century who had first established a chief judgeship centuries earlier in Baghdad, and he expanded his powers over ordinary judges. So it was a long time coming that the power, the religious or epistemic authority, and the extent to which the populace looked to and deferred to the chief judge had been coming. So by Mamluk terms, the protracted Mongol invasions and the other internal problems in administration created a situation of weak government and strong judges. The jurists and the judges did more to bind the Muslims together than did the faltering centralized government. And so they were seen even more so at that point as the legitimate exponents of Islamic law. So then by the time our case unfolds in 1265, Sultan Baybars knew that, and he was also primed to make reforms that would seek to weaken the power of the judge. In the aftermath of the case, then, the Sultan imposed 3 significant changes on the structure of the judiciary. The first one I've already mentioned, he elevated the deputies of the other 3 main approaches or schools of Islamic law to chief judge, so that there were 4 chief 4 chief judgeships. Second, he required judges to impose the majority opinion of each of their legal schools. So there was a tremendous diversity of opinion amongst scholars in any one legal school. So imagine that the scholars were the non-appointed jurists, much like law professors, who are arguing and debating about any given point of law, even within their chosen approach to law. But even with that diversity, some trends emerge. And so the sultan wanted to restrict or ordered the judges to restrict the judicial interpretations to the majority opinion amongst the scholars of any particular school, so that it could, in part, so that it could be identified rather than arrived at in every legal case. And then third, he used the courts, as did judges themselves and as did ordinary petitioners, to kind of forum shop, to secure desired outcomes by directing certain cases to school affiliated courts that were given subject matter jurisdiction or the equivalent of subject matter jurisdiction over certain types of law. So I want to turn now to talking a little bit about the significance and aftermath of the reform. Sultan Baybar's reform of the judiciary, it's probably, I'd say it's the most debated episode in the history of courts in the Islamic world since Harun al-Rashid first introduced the office of chief judge almost 500 years earlier. Medieval sources mark the event as momentous. Modern historians focus on the event as momentous. And these, my colleagues or contemporary legal historians have each offered their own interpretations of these sources, assessing the explicit claims about the motivations for the reform, the fallout after the reform, and many other questions regarding how the reform actually operated. And all told, legal historians in this field agree that domestic-facing factors of the type I've laid out prompted a need for the judicial restructuring in ways that altered the balance of power between the varied institutions and formed a new symbiosis, but symbiosis nonetheless between the scholar jurists on the one hand and the political authorities on the other. But most of these accounts focus on the institutions themselves and the ways in which the legal schools expanded or contracted, became more solid at that point in interactions with another and with the Sultan's government. None of them have paid attention to the fact that legal canons emerge at precisely that time as a separate genre of Islamic law, or to the way that those legal canons operate. So this is the untold, I think, but all too important aftermath of the reform, to which I'll now turn to delve into a little bit more. What were the legal canons and how did they operate? So what are legal canons precisely? They're succinct statements of interpretive principles that express varied conceptions of law and its values, and they're designed to aid an interpreter in applying laws to specific facts. Now, this definition can go for American law as much as it can go for Islamic law. But in Islamic law, to be sure, I want to emphasize that these legal canons themselves, each individual canon did not emerge sui generis after Baybar's, the Sultan's reform. Most of the legal canons existed well before the Mamluks. And they were first announced, for example, in works of hadith or statements attributed to the Prophet, which form a source, the second source of Islamic law after the Quran. They're present, for example, in advisory opinions or fatwas that judges had issued over the first 6 centuries of Islamic law before this point. And they come up in all kinds of works of law, legal treatises, historical chronicles, and records of judicial decisions. So you'll see legal canons there in the way that you see legal canons in many cases that you can pick up today from England or from US reporters. Reference to legal canons like innocent until proven guilty, or similar canons of that type. Now, what was new? Jurists of the Mamluk era identified and sort of extracted those legal canons from the prior cases and works of law. And for the first time, en masse and school by school, they collected these canons, organized them into independent collections of them, and placed them in some hierarchy, because what often happens is that canons conflict. Carl Llewellyn, when talking about legal canons in American law, famously wrote this article about dueling canons, right? And maybe there's canons are just a tool for the activist judge to pick whatever decisions he wants and to hide behind a veneer of legal canons. Since if you can, for every canon you can find, he said, there's an opposite canon. So Muslim jurists noticed the same thing, but accounted for it in part by accounting for differences in the varied, multiple, pluralistic approaches to law, each of which was seen as equally authoritative. And their move, which I think we haven't done yet in American law, was to separate them out and place them in some sort of hierarchy. What canons take precedent from other canons? What canons are accepted? What canons are rejected in each legal school? So how did Muslim jurists specifically define legal canons? For them, Islamic legal canons are interpretive principles reflecting changing conceptions of Islamic law and its values. They define canons, medieval jurists define canons narrowly. So the definition I just gave you was my own. But the medieval jurists said they were text-based principles used to apply general Islamic laws to particular cases. So for example, a famous universal legal canon articulates a general policy applicable to many areas of law, that the law should neither allow harm nor retaliatory infliction of harm. Judges, we can call this the no harm canon. So judges could use this no harm canon to evaluate contested individual actions and determine, for example, that if they're weighing two options that the law equally supports, they will come out on the side of whichever action does no harm to the most vulnerable petitioner in view of that canon. So it acts in that case as a tiebreaker. Another canon, a contract law canon, stipulates that Muslims must honor contractual conditions. So we can call this a contractual condition canon. And that similarly announces a value, in fact, that the collective juristic community placed on commerce and private contract. Conditions were to be upheld. And then a famous and widespread canon of criminal law, and one that I've written about extensively, had to do with something like a medieval Islamic law of reasonable doubt. That canon, the doubt canon, said that judges must avoid criminal punishment in cases of doubt. And jurists and judges alike define the ambit of this doubt canon to signal values and presuming innocence, requiring clear statements of law before concluding that a violation of a criminal law had occurred, and narrowing the institutional authority to define crime to just God and not not judges or jurists. God as legislature or legislator. So numbering in the thousands or maybe tens of thousands, we don't know yet, we need to count the canons. The legal canons, these Islamic legal canons arose and were implemented during Islam's founding period, sort of the long period leading up to this 13th century judicial reform. And they span the gamut of questions of Islamic law as they continue to spread, appearing in a wide range of sources for Islamic law and for judicial practice. So they appear in works of substantive law, in legal theory, in judicial procedure manuals, in biographical dictionaries, in historical chronicles, in literary works, and more. But the big contribution of the jurists, again, during the Mamluk period was to constantly collect these legal canons in independent sets of treatises and use them for pedagogy, for guiding judges, and for stating what is the majority opinion or what points to the majority opinion in each legal school, so that the canons could actually function as interpretive guides, as tiebreakers, as gap fillers, and expressions of values or policies from the Islamic law side. So the two leading schools in the Mamluk period, perhaps unsurprisingly, produce the most robust volumes of work in this area, even though all four of the legal schools and additional schools, Shi'i schools, who are minority jurists not recognized by the Mamluk state, all produced multiple works of legal canons over, I mean, there was just this explosive growth of writings on legal canons, collections of them, and scaffolding on top of that. So you had the two leading schools, the Shafi'is and the Malikis, writing at least 7 volumes of leading works each in the ensuing 3 centuries. So I suggest that there were several factors that played a role in why these two schools in particular led the charge. Political patronage, the prior history of each of these schools with some sort of political patronage were 2 factors at play. But the one that I want to emphasize, there's another one that I want to emphasize, and that's that the way that the legal canons operated in and alongside the new judicial reforms that made one legal school for each court. So I suggest that the Mamluk judicial reforms brought on forum shopping from above and below in the courts. And there's evidence to demonstrate exactly how in family law cases and criminal cases and tax law cases. And in the new system of legal pluralism, that demanded clarity in both substantive and interpretive terms for what was likely to happen in any one of the courts that the sultan and his men might choose to bring a case in, or an individual litigant and their family members might choose to bring a case in. So the clarity demanded implicated legal canons, and it created a new function for them. These legal canons now provided an acceptable escape valve from the pressure cooker of some of the rigidities of the new judicial structures. One cannot always refer a case to another court to get a different outcome once they had initiated a case in a particular court. But the new system would allow for a type of interpretive leeway, or the use of legal canons allowed for some interpretive leeway and further guidance and clarity on the law at 2 points. One, even before a litigant or an official went into court, and then once in court, it allowed for some judgment as to the legal outcome through a very active process of interpreting law. And I'm happy to talk about that in the discussion portion if there's appetite for it, on exactly how this operated. But I want to come to some close here and kind of step back and think about, well, what does all this mean? So what I've tried to suggest is that legal canons were an important new innovation as a genre in the Mamluk period that began in the 13th century. But legal canons weren't new under the Mamluks. Rather, those canons as an independent genre of authoritative principles that would operate to guide interpretation or to inform interpretation in court, and the explosive growth of and organization of legal canons were new. Expansive writings on legal canons grew out of the judicial reform, and it shows ways in which, sure, the symbiosis between law and governance, or between exponents of law, the scholar jurists and judges, and the political officials, sure, there was still that symbiosis, but it showed ways in which structural political changes had real effects on interpretive changes in Islamic law. The cases, when one reviews the cases from this period, they illustrate this pretty complex institutional dialectic that followed on from the judicial reform and the accompanying growth of legal canons. So one could say that the case that led to the reform itself, or purportedly led to the reform, shows that the executive recognized the jurist's power over defining the law and the judge's power in implementing it, and creatively came up with a way to assert his own effect on the system. And the judicial response, or the juristic response of those interpreting the law and helping to define the law, was to use standards, not rules, to use legal canons above static textualist laws to provide the proper interpretive structures that they needed to make the system work, and to gain back some of the interpretive power that they had lost through the reforms. So in conclusion, I argue that beyond the codification of substantive law, or the recognition of 4 schools of jurisprudence, the 4 mainstream schools of jurisprudence that emerged during that time, Sultan Baybars's judicial reform sparked a major development that was key to the new institutional symbiosis and to the meaning, the very definition of Islamic law that's gone largely unnoticed, but that bears enormous implications for today. The codification of canons that are necessary to identify, interpret, and apply Islamic law in that regime and perhaps in any. And I further argue that these legal canons operated as kind of a common law type interpretive precedent. They weren't created wholesale, but they were picked from earlier cases. And as time went on, legal canons were added to as cases demanded it. So these rules were drawn from past usage and settled law amongst jurists to provide persuasive guidance for resolving new cases and controversies in later courts. And finally, I argue that the canons offer a sharp window onto the shifting structures and values that their underlying rules helped constitute systematically and over time. So it could be that jurists of one school often adopted a legal canon, a particular legal canon over that of the one that might be privileged of jurists in another school. But that was often the result of debate and contestation. And that then became the stuff of Islamic law, that it was a result of debate and contestation and represented rather than static texts that were seeking to achieve some original meaning. They operated in a way that was dynamic and evolving with respect to the times. And so with that, I will close, and here's my one line on data science methods and its relevance. And that is, and frankly, I think this could go for Islamic law too, that is that this is an enormously fruitful and exciting area of further and future study. And wouldn't it be great if we could count up the canons, sort of attach to them what functions or values were at stake, and then note how they might have changed over time and space. And what does that tell us about the evolving principles or values that stand behind interpreting Islamic law? Thank you.